Good afternoon, you two. Appearances on the People versus Littleton, please.
Good afternoon, Your Honor. Elizabeth Moore on behalf of the people, P84724.
Good afternoon. May it please this honorable court, William Noakes, P42796 of the Neighborhood Defender Service of Detroit, on behalf of Mr. Eric Littleton.
Good afternoon. All right, Mr. Noakes, you did not file a written response, correct?
I did not, Your Honor.
Okay, I just want to make sure I'm not looking for something. Hopefully you've seen the People's motion.
Yes, I have, Your Honor, and I do have a response that I'll make orally on the record.
That's fine. Ms. Moore, if you want to hit some high points, feel free. If you don't want to do that, I have read it.
Thank you, Your Honor. I just want to briefly go over a couple of things. The court is well aware of the basis for which the people are requesting this. This is not something that I do in every case, even though I think that the governing law or rules would allow it, but I think the circumstances are sufficient enough that this should be considered. I will note that there are two conflicting authorities here. There's the court rule, which says that the court has the discretion or the permission to allow any witness to testify via Zoom. It does not state that a complaining witness is not allowed to testify via Zoom. And there's a statute that is a little bit more limiting and not allowing a victim to appear via Zoom. But I think that what makes the people's argument compelling in this case is the fact that when the court rule is conflicting with a statute, it is actually clear based on case law, and that's People v. Gecky 457 Mich 442, a 1998 case, citing the Michigan court rules that states that when there are conflicts between court rules and statutes, the appellate courts in Michigan have ruled that they are resolved in favor of the court rule because it is a rule of procedure created by the courts. The last thing that I'll note is that the right to a preliminary examination is in fact a statutory right. It is not a constitutional right. The defendant is not entitled to this hearing. It is something that Michigan has built into its court system. And so as a result, none of the defendant's rights are being violated as long as the defendant himself has the opportunity to be present in the courtroom for the exam. And so with that, I'm asking that the court use its discretion and allow the victim to testify via Zoom.
Thank you. Mr. Noakes.
Your Honor, there are 2 points that I'd like to make. The first is that, yes, there is a statutory right. The statute makes clear that Mr. Littleton is entitled to have the witness in the courtroom. And despite the fact that we're talking about the court rule not requiring that, I believe it is important that that happen. The second point is that as the attorney who will be cross-examining the only witness in this preliminary exam, it's important that that person be in person, because in that way I can determine how fast she's breathing, whether she's sweating, anything that could indicate to me that she's not being fully truthful. And it's important that I have her there so that I can actually represent my client effectively. And an effective cross-examination really does require a witness to be in front of you.
Anything else?
No, Your Honor.
All right, any response, Ms. Moore?
Brief response, Judge. As the court is well aware, the basis for preliminary examination is just to establish probable cause, and the issues there are usually an issue of law and not an issue of fact. Some of the factors that Mr. Noakes is bringing up, his ability to judge the victim's demeanor, her breathing, a lot of that goes to credibility and not the actual basis for whether or not probable cause exists. So I think that that's something else the court can take into consideration in using its discretion.
Right.
Your Honor, Your Honor, one last thing. Credibility is a factor to be determined by the judge in the judge's discretion at preliminary examination. And credibility turns on a number of things, whether she's breathing fast, whether she appears to be dissembling, whether she's mumbling when she's giving an answer. And the fact is that sometimes preliminary exams result in the dismissal of a charge based upon the credibility or lack of credibility of the witness.
All right. Thank you both for your arguments. I probably have not dismissed in my 27 plus years more than probably 4 or 5 exams based on credibility. And when I have, it's been because one of the witnesses' testimony was so totally out there incredulous that there was no way I could lend any importance to it. So I'm well aware of the fact that I get to judge credibility. I'm also well aware of the fact that most of the things that I would judge credibility based on will be evident if it's a decent video hookup at all. And if it's not good enough for me to hear her, then we're not going to proceed that way, and we're going to have to adjourn things until we can get a better hookup or have her in person. I'm also not. I'm also going to make note of the fact that she was here on July 30th, and it's my opinion that the reason we didn't go on July 30th is because Mr. Littleton has decided he's going to play the game. She was here. If he wanted to be present in person for an exam, that was his chance. I am not making that woman fly thousands of miles to be here for a preliminary exam when the court rule says it's my discretion. Anything else so you can build a record if needed, Mr. Notes?
Well, the only thing I would say is that I wasn't responsible at all for what happened on July 30th. This case was not assigned to me until well after that.
I did not mean to suggest you were. I think that is clearly on Mr. Littleton because he wanted to play the insanity game. Anything else?
No, Your Honor.
All right.
Judge, may I just address one thing?
Sure.
So given the fact that we just had connection issues with the competency hearing that we had, and that involved a government employee who was in her office, I've already spoken with the victim about how to get a good video connection should the court rule this way. The only thing that I want to note is because of the time difference, 1:30 our time is about 3:30 in the morning her time, and so her options of where, like, she cannot go to a public library with a better connection because it's 3:30 in the morning. So we are looking into that, and I just want the court to know that's not something that I take lightly. I recognize that the court's discretion, and I'm doing everything that I can to work with the victim to make sure that we hopefully will not have those issues.
All right. Yeah, I'm going to make a suggestion. When you figure out where her best place is to do it, let's set up a test run. You can contact Heather, and we'll do a test run, days before the exam is scheduled.
Okay, thank you, Judge. I will do that. I'll speak with her about that, likely this evening, because that will be tomorrow morning her time, and we'll get that set up. Thank you.
And I'm not, Mr. Noakes, I'm not suggesting that all hands on deck. I'm thinking that's Miss Moore, her complainant, and Paula checking my courtroom equipment to see if she can hear things.
Yes, I understand that, Your Honor.
Excuse me, Judge, who's Paula?
Oh, I'm sorry.
You're in trouble now.
I was talking about Tammy, Heather. Sorry.
Well, Your Honor, in order to accommodate the hearing, and given the fact that there's a 15-hour time difference between here and Australia, would you consider a different time? I don't know if that's something that APA Moore is interested in, but given the 15-hour time difference.
I don't know what time we could set it that would be much easier on the complainant.
Well, 4:00 in the afternoon would be roughly 9 a.m.
I think
Or
4 o'clock
8
in the afternoon would actually be 6 a.m. But I do think that something like that could either be more interesting to the victim, or the other option would be, I don't know if the court ever schedules anything for 8 o'clock in the morning, first thing, but that would be 10 p.m. her time. So much more feasible as far as things are concerned.
Well, I'm willing to consider either one. I mean, there are obviously, my concern with staying late is time and staffing. But we've got a couple evenings in the week where we've got security here after hours anyhow. So I'd be perfectly willing to have Heather find you a date at 8 a.m. or 4 p.m. or 3 p.m. or whatever.
Either 4 p.m. or 8 a.m. is the people's preference, and I appreciate the consideration of the victim's time frame. Mr. Noakes, what's better for you?
I don't disagree. What day are we going again?
We're scheduled for Thursday, April 2nd currently.
Yeah, then I don't disagree with 8 a.m.
Well, we can't on that day. We have a whole docket that day.
That's why we gave you the afternoon.
Yeah, that's why we did the afternoon.
Well, then 4 p.m.
Let's look for a 4 p.m. Heather, do you know what days there are that our guys are late for GrowthWorks?
I think it's a Tuesday, Thursday.
Let me call them real quick.
Okay. If it is a Tuesday, will you guys look at April 7th? Because I know that that day.
Hey, Glenn, What are your late nights with Grow Force? Tuesday and Thursday? Thank you. Tuesday and Thursday, correct.
The 7th will not work for me because I start trial on the 6th, and that's likely to last 3 or 4 days.
And on the 9th, we have jury trials. The 14th, judge is off. We could go to the 16th.
That should work.
Okay, hold on one second. What about you, Elizabeth?
Can you just give me one moment?
Yeah.
Thank you.
Yeah, I could do April 16th late.
Well, we're waiting for Elizabeth is looking
fine.
at things. Because otherwise, we have no 8 a.m.s except like on a Friday.
Right.
I think
I think if I was her, I'd rather do it at 9 o'clock in the morning than 10 o'clock at night. And that would give her more options for finding Wi-Fi, I would assume.
so just to be clear, it's 6 a.m. would be her time if we did it at 4 o'clock. So
Okay.
so I actually don't know. I don't know what is the better
Right.
what is the better alternative there.
Yeah,
Well,
because
you want to
depending
wait
on
until you figure that out and then we'll pick a date?
I don't want to continue to create more stress on all of you. I do think I will talk to the victim tonight, so I could, as of late tonight, have an email out to you guys for scheduling. Would that work?
I'm all right with that, Mr. Noakes.
It would. I'm going to reserve the 16th so that nothing else gets
for the
put
4
in.
p.m.
Yes.
But then, Judge,
Fine.
will you look at? I mean, what about a Friday 8 a.m. on the 24th
Of April,
of April?
right?
Right.
Mhm.
I mean, because those are the only 2 days we have the and then it would go to the 28th for a 4 p.m.
What do you guys anticipate this will take? Hours? How many hours?
Judge, I think we could move fairly quickly. I think an
2 or
hour
3?
to 90 minutes.
I would agree with that.
Okay,
Yes.
then I can do 8 o'clock on the 24th.
Yeah, so I'm just giving you options, Elizabeth, so that you don't have to try and play tag with her. That's
Yeah.
why I'm trying to create different days if you guys are available.
Okay, thank you. So it's 4:16 at 4 o'clock.
Yep.
4:24 at 8 o'clock, and then did you mention one more?
Yep, 4:28 at 4 o'clock.
Okay.
Okay.
Thank you so much. I will go to her with all of those and see what works best. Thank you so much.
Mr.
Okay.
Noakes, did you agree on those two, the 24th and 28th?
The 24th is good. The 28th,
Would be 4 p.m.
4 p.m.
Well, I thought we were doing the 16th at 4 p.m.
Well, I'm giving her options, Judge, only
Okay.
because she's calling the victim and we don't know
No,
what's
that's
better
fine.
for her.
I'm okay with 4 p.m. on the 28th of April as well.
And
Okay.
the 24th would be at 4 p.m.
No, the 24th would be 8 a.m.
Okay. Okay, those appear to be fine right now. I've just got to, I know I have a trial during one of those weeks and it may bleed over into Friday, but otherwise we're good.
Okay, all right. We'll stand by then.
All right, thank you.
Thank you so much.
Thank you. Have a good day.
Heather, you want me to shut down?